myself, Dr. S.B. Gayatri, presenting Articles of Association in Company Law under Companies Act 2013. Company. First, before getting into Articles of Association, you all must know what is company. Company is an artificial person created by law having a common seal and perpetual succession. As said in the definition according to Professor Hanley, company is an artificial person created by law having separate entity with a perpetual succession and common seal. It is not an individual person, it is an artificial person. So always it should be with the common seal and perpetual succession. Perpetual succession here refers to the long run of a company. Articles of Association. Articles of Association and Memorandum of Association are the most two important documents in company law. Articles of Association is an important document in joint stock company and it contains all the rules and regulations and bylaws of the company which is related to the internal working management of the organization. It plays a pivotal role in all the affairs of a company. It deals with all the rights of the members of the company among themselves. And with related to the contents of Articles of Association, it should not be any contradictory with the Memorandum of Association. The Memorandum of Association, that is MOA, is entirely different from Articles of Association. Contents in the Articles of Association. What are the contents in the Articles of Association? The classes of shares, their values, rights attached with them are all described in the contents of Articles of Association. Calls on shares, transfer of shares, forfeiture, conversion and alteration of capital all should be clearly described in the Articles of Association. And with regard to the directors, their appointment, powers and duties should be described. Meeting and minutes of the meeting, notices etc., accounts and audit procedures, appointment and remuneration to the auditors, voting poll, proxy, dividend reserves, procedure for winding up, minimum subscription, rules regarding the use and custody of common seal. All these things should be clearly defined and how it can be used and all those things has to be presented in the Articles of Association. Alteration in Articles of Association. Sometimes alteration can be done with some permissible limits. The alteration of the article should not sanction anything illegal. Definitely it should be a legal thing, only then it can be altered. The proposed alternation should not be contravene the provisions of the Companies Act, should not contravene the provisions of the Companies Act. The alteration should not propose anything that is illegal. The alteration should be bona fide for the benefit of the company. Similarly, the court does not have any power to order alteration of the Articles of Association. And the duties of the company secretary in alteration of memorandum and articles. In case of any alteration, the following things has to be done. That is name class, object class, capital class, registered office class, liability class and subscription class. That is every alteration mode in the memorandum of a company shall be noted in every copy of the memorandum or articles as the case may be. Then steps for alteration in memorandum of association. The first step is issuing notice of board of meeting to all the directors of the company at least 7 days before the date of board meeting. Agenda has to be attached and the notes to that agenda has to be also attached and resolution has to be enclosed. And the step 2 is to hold a board meeting. At the board meeting, the resolutions in respect of alteration in MOA must be passed and approval has to be done with a special resolution. And the date, time and venue has to be intimated in prior. Then issue of notice in general meeting, to whom the notice should be circulated to all the directors, members and auditors of the company. And to hold general meeting, the quorum has to be checked and the presence of auditor, any special resolution, the approval of alteration in MOA has to be checked. Then it has to be done along with the stamp duty in alteration. The company can alter its subscription class. The company in its lifetime can't alter the subscription class. It can be done, it shall be used for the lifespan of the company. Duties of the company secretary in alteration of Articles of Association. The Articles of Association of a company are its bylaws or rules and regulations which govern the management of its internal affairs and the conduct of business. They are framed with the object of carrying out the aims and objects as set out in the Memorandum of Association. And in case of steps for altering the Articles of Association, the board of meeting has to be convened and it has to be done. And after convening the board of directors meeting, a notice has to be served at least 7 days in prior to get the approval, and the general meeting has to be held and the resolution has to be passed. Thank you.